Welcome to the Mr. Beacon podcast. We're going to be talking about the General Data Protection Regulation, or GDPR, which is really, really topical. You've probably been getting a whole bunch of notices from the companies that you rely on to run your business. This goes way beyond the Beacon ecosystem. And this week we have a return guest, Jarno Vanto, who is a partner at Polsinelli. And is a real specialist in this area. We're a little biased because he wrote the chapter on privacy for the Beacon Technologies book that we collaborated on, which is excellent. Jarno, welcome back to the Mr. Beacon podcast.
Thank you. Appreciate it. Great to meet you again, Stephen.
Yeah. So last time we spoke was episode 15. This is actually episode 70. Can you explain why is GDPR topical at the moment?
Well, GDPR is the European Union statute that replaces the current European Union Data Protection Directive, impacts all businesses that either have an entity in Europe or that offer goods and services to European consumers. So that captures a large chunk of, for example, US companies that provide apps or other mobile technology, collect personal data. And when I say personal data, it's really understood broadly in the US, when you compare it to the US context. So in the US, we typically talk about PII, personal identifiable information. That's understood very narrowly to mean things like social security numbers, email addresses, those types of identifiers where you can directly identify who that person is. But GDPR covers all processing of personal data, which is understood very broadly. And so, for example, mobile device IDs that many mobile apps collect are personal data. Website cookies are personal data. And so you're really looking at all IP addresses online are personal data. So you're really looking at everything that a modern company does right now. And you have to have critically, you have to have a good understanding of, well, first of all, what personal data you collect, where you store it, how you can, for example, give users those rights that the GDPR gives. So, for example, practical example from a talk with a client a couple of days ago. They collect a lot of data online and do website tracking and all that that any company basically does these days. And imagine when a consumer comes to you and says, "I want to know what personal data you hold about me." And so you have to understand what is personal data, but then where you store it, you can store it in like cloud services, your own servers everywhere. And then what if the consumer then asks, "I want you to delete all the personal data that you have about me?" And the calculation was that if it was done in the current system, one such request would cost anywhere from $1,500 to $2,000 per request. So that means that companies have to overhaul their systems, reorganize their databases in order to really comply with the GDPR. So it's a huge effort, and it's not just a legal effort. It's also in a large part, it's a technical effort.
And just to make things a little bit more fun, a little bit of time pressure as well. When does this regulation go into effect?
May 25
of this year.
Yes.
Okay. So this is why we've been getting this flurry of updates from all of the service. So we have a web service provider, we have Salesforce. I'm just talking about the Wiliot, the company that I work for. And, we don't even have our product out yet. And yet we have three major systems that we use, Salesforce, marketing, website hosting, that are all impacted by this. Goodness knows what it's like for other companies. But, we're in the States, and I occasionally go to Europe. Does this affect companies like ours who are based in the States?
Well, it depends. Everything is about how your company does business. So, for example, if you have European consumers, customers of your business, you're clearly impacted. But if, for example, you're providing services to a U.S. company, and in connection with those services, you have access to their EU customer data or EU employee data, you're impacted. And what your customers will have to do is to make sure that all those vendors that they use, including, for example, your company, if you were such a vendor, they have to make sure that those vendors are in compliance. So, for example, vendors can't subcontract the processing without authorization. Vendors have to have proper data security systems in place. Vendors have to notify about data breaches, all that. So it is really, I mean, Johnny come latelys are always, there. But really, given that we have a month, especially if you're in the consumer space and with your products and services, you really gotta get working on this.
So what if we're a business, and we're going to get onto beacons later, but this is just kind of the basics of any business. It seems like every business has an online website at the moment, and it's not realistic to say, well, we're only offering this website to people in the US. You're going to get people from Europe registering. So if I have a web service that does some kind of location-based service, it uses GPS, so it doesn't have beacons, and some of those people are in Europe, then does it affect my business?
A good question, and some of these judgment calls are a little bit challenging to make right now, since we don't have a single enforcement case yet, because the statute enters into force on May 25. But if you're not, for example, actively promoting your mobile service, for example, offering it through European app stores or your website, you're not marketing to European consumers, it's highly unlikely that you'd be a focus of any kind of enforcement activity. So if you're just offering your service to U.S. consumers, also specifying in your terms of service that you're really just offering this service to U.S. residents over the age of 12, well, you're probably not going to be an obvious target for any kind of enforcement activity if you don't comply.
Okay. But if you have, but if you're basically selling to the European market, or you have going through channel partners that do, then they kind of get you through this this web. Even so, one of my questions is, okay, I'm over here. You happen to be in Europe at the moment. You're based in New York. You're in Finland. How? One of my questions was going to be, how can the EU touch me when I'm in the United States of America? But I think part of your answer to that question is because I have to deal with European countries and they're under obligation for me to conform to the rules. Have I got that right? Is that the...
Well, yeah, I mean, the GDPR, the language of the regulation talks about offering goods or services or having an establishment in the European Union. So even if, and that means basically a company in layman's terms. If you have, for example, a subsidiary in Europe, you're clearly covered. But even if you don't have a subsidiary covered in Europe, then you'd still be covered if you offer goods or services to Europeans. But how it really passes through the entities that are not impacted by those two major factors is that if you are a service provider to a company that must comply, then you also must comply. And this is one of the sort of the ideologies behind this regulation, that Europe wants to make its privacy standards global. And in some ways it is doing it, because right now US companies that never thought of having to comply with European privacy rules are suddenly facing these questions from their customers or their vendors. What are you going to do?
Yeah. It's a little bit like the Californian car emissions regulations. It's like, if you're going to sell a car in California, then you need to meet our regulations. Well, that basically means they raise the bar for pollution standards to kind of the whole of the United States, because every car company wants to sell to California.
But I mean, like a U.S. domestic example of this could be on the data side. For example, that Massachusetts was one of the first states to impose strict data security requirements on all companies that process PII of the residents of Massachusetts.
Mm-hmm.
Unless you completely want to build a fence around the state of Massachusetts, you'd basically build your data security program around the strict requirements of Massachusetts instead of doing a piecemeal state-by-state approach, because that's the easiest way to comply, right?
All right. So I see a lot more of those annoying notices popping up saying, hey, did you know we collect cookies? No. Really? You collect cookies? It's like every website collects cookies, unless someone's coded it in HTML, and it's a high school project. So let's get into what this means. So it's very broad. It has some real teeth. It's happening now. What needs to get done in order to conform to these regulations? I think there's some kind of terminology that we need to get to. And actually, just maybe a more manageable way of coming at this is, how does this change from what the EU had in place before? Because from reading the chapter in the book and listening to episode 15 where you described it, I felt like the bar was pretty high in Europe already. How has it changed?
Well, you're right. So there's been laws around this in the books in Europe since the mid-90s, basically. So we're looking at something that's been in place for 30 years. The GDPR adds new elements, things like, what we've heard about right to be forgotten and some other elements. But really, it's building on an existing legacy statute. It was called the European Union Data Protection Directive. It's been in force since 1996. But what it introduces is more stick.
All right. Okay.
It has these potentially gigantic fines for non-compliance. So you're potentially looking at fines of 4% of the company's global revenue, by the way, not profit, revenue, or 20 million, whichever is higher. And so, for globally operating companies with billions in revenue, that could be a lot of money. So companies now have a real financial incentive to comply. And for example, things like, what the US had first and Europe did not is now a data breach notification requirement. And now Europe will also have a data breach notification requirement. And the timelines are fairly strict. 72 hours from after the company becomes aware of a data breach, the company has to notify the privacy regulator in Europe. And when you think about it, that's fast. But then you also think about it from a perspective of what is covered by data breach. So the U.S. data breach laws typically only deal with from social security numbers and credit card numbers and driver's license numbers, things that, again, obvious direct identifiers. This covers all personal data, and as we talked about earlier, it's understood very broadly. So losing, for example, a bunch of device IDs from an app server prompts a requirement to notify the regulator, and in some cases also the consumers.
Gosh. So what does it do as far as where data needs to be located? I have in my mind, if you're tracking the data about European citizens, the data needs to be in Europe. But is that really something that has to be?
No, it did. No, the European Union doesn't have so-called data localization laws in the sense that you would have to keep data in Europe. You can move data freely to countries that the EU considers as providing adequate privacy protection.
Okay.
Unfortunately, the US is not one of those countries. Europeans don't think that at this point US laws provide adequate privacy protection. But we have an arrangement where US company can self-certify with the Department of Commerce for the Privacy Shield. You've probably heard of Privacy Shield. And that is a legal way of moving data from Europe to the US. The EU doesn't require you to keep the data in Europe. You can move it, but you have to have a compliance mechanism like the Privacy Shield in place in order to do that.
And remind us what the Privacy Shield is.
It is basically an agreement between the US government and the European Commission that as long as a company tells that it complies with the so-called Privacy Shield principles relating to personal data and self-certifies their compliance once a year with the Department of Commerce, then they can freely move their customer and employee data to the US.
So tell us a little bit more about the things the US companies are having to do, the changes that they're having to make. You've already touched on a few of them. One was the right to be forgotten. What else? What are the other changes that you're seeing people putting into place?
Yeah. So again, everything with the GDPR has to do with what the company does in practice. So there's no one-size-fits-all solution, because you have to look at the types of data that the company collects, who it's sharing the data with, where it stores it, what the core business of the company is. So, for example, there's been a lot of talk about this thing called privacy impact assessments. Privacy impact assessments are a GDPR requirement for when a company plans a new product or service that processes personal data, and that change or new product potentially has an impact on user privacy. For example, this is a big thing for companies, for example, that track people online or location-based businesses, because potentially the changes or new products that they create will have a huge impact on user privacy, because, again, for obvious reasons. And so they have to do what is called a privacy impact assessment when they make these changes and before they make those changes. So they got to actually document and assess, well, first, what types of impact on user privacy the change or the new product will have, but then also minimize the privacy impact by tweaking the product so that it has a minimal privacy impact. And for example, healthcare, companies in healthcare or health technology, they process what the GDPR calls sensitive or special categories of data. Health information, obviously very sensitive. And so they have to appoint a data protection officer to the company. And also companies such as online tracking, ad tech companies have to appoint a data protection officer because they do, again, monitor the online activities of users on a large scale. Initially, almost every company, in the first draft of the GDPR, almost all companies would have had to appoint a data protection officer. But during the last stages of fevered lobbying activity, they limited it to those types of companies that either engage in monitoring of people on a large scale or process sensitive personal data on a large scale.
Okay. So what about size of company? If you're a startup, you're a 10-person beacon startup.
Yeah.
I mean, that potentially is very personal information about where people are spending time. Does that mean you need to appoint a data privacy officer?
Again, the challenge is because it's using the language large scale.
Okay.
So when do you reach that scale is still a little bit unclear.
Got it.
But if you're tracking locations, of individuals, and it's relatively, you can very confidently state that you're doing it on a large scale. If you're, for example, tracking a number of apps or locations, but I don't want to, terrorize everyone listening to this podcast. But there's also this thing called the e-privacy regulation coming down the pike.
Oh, there is?
Yeah, there is.
Okay. Tell us about that.
The e-privacy regulation where the GDPR is sort of a general statute relating to all things personal data. E-privacy regulation regulates mobile communications. So the thinking that the Europeans had behind this e-privacy regulation is that they want to bring, back when, now there's this thing called e-privacy directive, which basically just regulated telcos. And then Europeans thought that it doesn't make sense anymore to have only telcos here because everyone is providing communication services now, all these apps where you can talk and message and all that. So they want to bring those under the same kind of regulatory umbrella as telcos. Mm-hmm. So that regulation has a lot of, for example, relevant to beacons. So for example, first of all, it requires opt-in consent for location-based tracking. Mm-hmm. Of basically all types, including beacon technology. Mm-hmm. But then it has, because the text hasn't been finalized yet, there's a draft. And again, like with the GDPR, there's a lot of lobbying activity going on right now in Brussels. Mm-hmm. For example, the draft language says that any location where user communications are tracked, whether it's beacon technology or Wi-Fi, or it would actually need to be things like warning signs that people actually are aware of that tracking going on.
Okay. Well, it's funny. So I don't want to turn this into a massive advert for our book, but that's something that we do suggest in our kind of beacon deployment guide, is think about that. Same way as you have warning signs if there's surveillance cameras and that sort of thing.
Yeah.
Not unreasonable, actually, in my opinion. But
so it's like everyone in this kind of business area should also keep an eye on that e-privacy regulation, because it will have an impact on all companies that rely on location-based services.
Very good. So any other beacon related pieces that you've come across? Because as a lawyer, I think, I don't know anyone who's spent, you've spent a lot of time looking at this. You work with some of the guys that are building beacon networks and using GPS and so forth to create new models, new business models. So any other things that we could be thinking about relate to these regulations and beacons and location services? Yeah,
I think that because beacons in and of themselves, as we know, they don't really collect any type of data. But the mobile device that interacts with those devices collects a lot of data. And companies that are providing support services, technology support services, for example, mobile apps and other technologies that rely on beacons or other, local support networks, they're in a little bit of a tough position right now, because one of the GDPR main, what they call legal basis for processing of personal data is consent, right? And if you're there in the background, then in order to get that consent, you got to rely on those publishers, apps or websites, or to collect the consent on your behalf. Potentially, we're going to see, again, more of those pop-up screens with disclosures about who they're sharing data with and all that. So it will be those support type vendors are going to be put in the spotlight much more than they have been in the past until now.
So if I'm a beacon startup, I'm creating this three-sided network. I'm bringing together venues that have beacons and people that are developing apps and brands that want to engage with people who are in certain places at certain times doing certain things. As you say, I'm working through third parties who have apps, and I need to make sure that they're getting consent. Is it enough that I just have a contractual relationship with them, or do I need to actually have a record of the fact that someone has actually specifically opted in? Can I just put it on the app vendor and have it in my contract and say, hey, I insisted they did that, and if they didn't do it, then it's not my fault?
Well, first of all, first party that collects the consent actually needs to maintain a record of it.
Okay.
And then they need to pass it on to you if you rely on it. And then on the other hand, when there's someone then withdraws their consent, since no more of this data collection business for me, then they also have to communicate that withdrawal of consent.
Of course. The right to be forgotten.
Correct.
Yes.
Yeah. And so then that means that, on the one hand, you have to have a contractual language in place with your publisher partner. But then there also needs to be, again, because the whole GDPR is really just also a technical effort alongside the legal efforts, that you then build a technical feature into the platform that enables almost automated connection communications.
Fantastic. Well, that's not fantastic. It's daunting, but last question is, do you think the net of this is going to be helpful or a hindrance to the kind of businesses that we're talking about? It's a huge amount of work, isn't it?
It is a lot of work, and lawyers are busy, but I think engineers are busier in some ways, trying to come up with technical solutions to enable this compliance. But there are arguments, and I think many of those arguments are valid, that when companies, they have to clean house as a part of this process, and for example, identify where they store personal data, what they do with it, all that stuff that's been kind of going on for a long time without anyone really checking into what the company is doing. It's good. Well, first of all, when you get consented data, it's good data. You can build better data products based on it. And then this cleaning house also means that, you have updated current data, and you don't have people in your database that don't want to be there. And so really, I think in the longer term, this will enable business opportunities that were not there before. And I think that overall that's a good thing.
I agree. I think you got to take the high road. What we're doing is pretty awesome, but with awesomeness comes responsibility. And we've seen with the Zuckerberg situation, it's such a distraction when you don't manage it correctly. And arguably, they actually did quite a lot of good things in terms of offering these options, but communicating clearly what is a key part of it as well. Correct.
That's true.
Well, Jarno, thanks so much. You guys, I know you're super busy given the timetable that we talked about. Jarno Vanto of Polsinelli, thank you so much for walking us through this.
Thank you so much. All right, you have a good rest of the week. Thank you.
Cheers.
Bye-bye.
So you get 3 extra songs. Last time it was Pink Floyd and Guns N' Roses, and so the one good thing about, other than the fact we get more of your time on this show, you're back. You get 3 more songs, so it's 6 songs on your trip to Mars. Do you have any thoughts on what those other 3 would be?
Well, actually, it's funny. I was in a train earlier today, and I was listening to the first ever pop song made with a synthesizer called Popcorn.
Oh, yeah, I remember that.
I hadn't heard that song in a long time, so I was like, this is a good one. I haven't heard this in like 15 years. But so that's definitely one of the songs.
So does it bring back memories, Popcorn? Is there a time when you first heard it?
Yeah, it does. We had, when I was in high school, I was a DJ in school dances, and one of the songs I played. So that's
fantastic.
That was definitely a good memory there. Yeah.
Yeah, the DJ was an exalted position at that.
Absolutely.
I mean, I think it still is, but you're a teenager and solve so many problems. You don't have to think about what to talk to people about. You just kind of sort of at the center of the attention, and you're in control. So Popcorn's one. Any others?
Blue Oyster Cult, Don't Fear the Reaper.
Oh, another classic. And your third?
This one needs a second. I think, of the more recent vintage, Khalid, young, dumb, and what's the name of the title of that song? I just loved it because I was listening to it on repeat. Young, Dumb, and Broke, I think is the song.
Okay.
This artist called Khalid.
Okay,
Yeah.
I don't know that one. I'll check that out. But I remember listening to Popcorn on a school trip to France when I was a kid. So it brings back memories for me as well. Very good. Thanks very much.